this morning on the Ag Issues program. A pleasure, as always, to bring onto the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine. Thank you.
Well, let's get right to it. And the first thing we want to talk about is something that we slowly have been hearing stories about, really about the past month or so, the bankruptcy of Hansen-Mueller. It's an Omaha-based grain company. You first started hearing about that in Nebraska, down in Texas, but pretty important here in the state of Kansas as well.
It is. Excuse me, Greg. It is. They have some pretty significant operations in western Kansas. And even last week, I was speaking up in Fargo, North Dakota, and I was informed that they do have facilities in North Dakota. And so it was affecting producers out there. Of course, I was talking to their CPAs and their attorneys, but they had been contacted by clients about it. So last week, when the news broke, I wrote a piece. It's posted on Ag Manager at K-State. For wide distribution that kind of talks about if you're a farmer that's affected by this, what you need to do, what the process is, what you need to do now, because there are some things that can be pretty timely in bankruptcy. Everything's governed by the bankruptcy court, and there are specific deadlines on certain types of claims that you can file, certain rights that you might have. And so farmers that have dealt with Hansen-Mueller need to be aware of what's going on. This is a reorganization bankruptcy. It's Chapter 11. It's not a liquidation bankruptcy, but nevertheless, the federal bankruptcy rules still apply.
So I guess at the core of it, what got away from Hansen-Mueller as far as not being able, and it sounded like a lot of it is once they got into harvest here, they weren't able to pay off obviously some of the producers out there with the money that they had, and then that slowly started growing into what we see now.
Yeah, I'm not sure of all the underlying factors that pushed them to file for reorganization bankruptcy, but because they have filed for bankruptcy protection, then they are currently legally stopped from paying past debts without court permission. And so the settlement that a lot of people may have heard about in the news regarding payments to farmers, that was specific to Nebraska and their Nebraska state licensure. And likely that settlement doesn't apply to Kansas growers automatically. So we'll have to wait to see more information come out of the court concerning that. But that one's Nebraska specific. But for our Kansas farmers, before anything else that we talk about, I would say that if you delivered grain within the 20-day period prior to the bankruptcy filing, so that's about October 28 to November 17, they filed on the 17th. So back it up 20 days, I think that would catch October 28 or 29, 30, 31, depending on how we want to count this. If you did deliver grain within that time period, then the portion of that debt might get what's known as administrative priority. So that gets paid in full before other old debts. And the Bankruptcy Code also gives farmers a priority claim. It's not much, but it is a priority claim for $8,450 per individual. Then if you have debt above that they owe you, from their standpoint, the rest of that debt above that amount is general unsecured. So that's where the main problem comes in for farmers. They're going to be a general unsecured creditor, meaning you get in line, but you get in line to get paid after their secured creditors get paid. That's how the bankruptcy court's going to sort this out. Everybody's going to line up. We have the secured creditors first. We have the general unsecured creditors that come after that. So this is, Greg, this is something that I've talked about for a long time. One of the things about selling grain on a deferred payment basis, and we often do that for tax purposes, and that's something that farmers find is a great tool. But the warning on that is that you need to make sure to the extent you can, of the financial footing that buyer has. Because if they're unstable and you deliver and then they file bankruptcy before you get paid, you're going to be a general unsecured creditor. Now, there are some things we can do to deal with that, such as escrow accounts and so forth, but a lot of farmers don't do that. So that's the warning when we use deferred payment grain contracts, or anytime there's a time lag between delivery and payment. We always have to be cautious to make sure our buyer is pretty financially stable, or else we can run into some problems.
The key there on action steps to take, obviously documentation. But, filing the proof of claim, you should do that fairly quickly.
Yeah, that needs to be done immediately because, as I said, you're going to be considered an unsecured creditor. So you have to formally tell the bankruptcy court that they owe you money, or you may not get paid from any asset sales. And so I have in my article the link to the court that has appointed a specific agent to handle those claims. And there's a link to give you access to that agent to get your claim filed. Plus, they give you a phone number and the website in terms of how to file your claim. So you need to do that, follow the instructions. Now, my suggestion is that farmers get legal representation, a good bankruptcy attorney that has helped people through these types of situations before, help the various farmers that are trying to get paid in this process. But I do give you kind of the outline of where to go, where to find information, and what to do. But yes, gather your information first. Get all your scale tickets, all the tickets for grain deliveries, any written contract or confirmation of sale that you signed. If you received any partial paperwork, settlement sheets, even if they're unpaid, make sure you gather those. And any text or emails where you asked for payment and they responded or didn't respond. You want to gather all of that first and then file your proof of claim ASAP. You want to do that right away. And the other thing, Greg, is you might want to check for bond protection. I think that's a critical step for a Kansas farmer. Hansen-Mueller was not a licensed grain dealer by the state of Kansas, which is going to limit state-level help, but they often operate under a federal grain warehouse license. So for farmers listening that are affected by this, look at your scale tickets. What do they say? Do they say issued under U.S. Warehouse Act, or do they have a federal license number on them? And that really matters because if the transaction falls under a federal license, there might be a federal surety bond available that can pay you faster and more fully than the bankruptcy court. So that's one thing to have your attorney check, or you check and then have your attorney check that. And then perhaps contact the USDA Warehouse and Commodity Management Division. I do give the phone number for that division in my article to ask if the specific facility that picked up your grain is covered by a federal bond. You want to kind of know what the landscape is, and those are the questions that I would ask.
Well, then the obvious next question would be, nothing is a fast process as far as this type of situation is concerned, i.e. a different situation, but one comes to mind, the situation a few years ago with MF Global.
Yeah, it's the same process, and you're right. The bankruptcy process, the legal process, is kind of a grind here. It's very unfortunate for farmers that have gotten caught up in this, but you do have to participate in the process. There's no way to so-called jump the system and get it to the front of the line necessarily. You may have priority, but it's doubtful for many farmers because the Hansen-Mueller's major creditors are going to be sitting there first. They're going to be taken care of first before the unsecureds. But you always want to check your documentation. Again, watch that 20-day timeline. You're going to have a preference if you deliver grain within the 20 days before the bankruptcy filing. But again, that doesn't start until really late October, and a lot of people had harvested grain and delivered prior to the end of October. Or shortly before the end of October. And so you may not have that 20-day preference, but it is a process. It's going to take time, and that'll create a strain for the farmers that are affected by this on cash flow.
And they can go to the agmanager.info website where you've got all that information.
Right, and I posted this on November 19, so as you scroll down, those are cataloged, all the articles there are cataloged by date, so this one was put up on November 19, last Wednesday.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is joining us. And Roger, you always hear that farmland values often capture headlines in agriculture, but there's a more subtle yet relentless source of financial pressure for farmers and ranchers, and that really lies in the property tax on business assets.
Yeah, that's right, Greg. And I've heard a number of things about this in recent months. You always kind of hear these things when I'm out speaking and talking to farmers and others. But this concern has really ramped up. The tax has become significant and I think pretty highly visible. And of course, when you got your margins that are tight anyway, and you're trying to optimize the income from your operation in the most tax efficient manner. This can be something that can threaten liquidity and discourage investment in new assets and create a disproportionate burden when it's compared to other industries. And I'll explain that in just a second. But what the main problem here is that because farming today is very capital intensive, you look at and you price a combine, you're talking hundreds of thousands of dollars, combines and tractors and those types of things, planters and sprayers and trucks and so forth, all that specialized equipment that farmers need. That's a multi-million-dollar investment, just even for a mid-sized operation. Now, the problem that we get into is that the taxable value of those assets is often based on their original acquisition cost. So I buy a $700,000 combine, for example, and with 100% bonus depreciation, that's great from a federal standpoint. I write the entire cost of that off. And so if I'm in a 30% tax bracket, the government's going to partner with me on 30% of that price. And so it's going to drop that effective cost for me. Now, I don't have any basis that's remaining, and I'm going to continue to depreciate that asset. But, I don't know if you've priced used farm equipment recently, but those assets hold their value for a very long time. And what's happening is that the property tax is often based on that initial purchase price, and it doesn't adjust downward as that asset is used, or it doesn't adjust downward as fast because the state has a different schedule than does the federal government. So in another piece that I wrote, this one I put out, it's also on Ag Manager last Monday, so November 17, I go through what might be some state approaches to provide some relief. And one is expanding the direct exemption for farm machinery and equipment that we have. If, for example, if we have assets that are used in the direct production of agricultural commodities, then you've got a sales tax exemption, and we have some limited property tax exemption too. And maybe the legislature can take a look at that, maybe tweak that a little bit, or lower the assessment ratio or the cap. Instead of a full exemption, states, I think, can take action, and this would include Kansas, to reduce the taxable value of ag assets by requiring a lower assessment ratio. That's the percentage of market value that's taxable for farm equipment compared to other business personal property, or put a maximum assessed value cap on it. Some states do that, and I give some examples of that in my piece. And then maybe change the depreciation schedules. But whatever they do, there's going to be political trade-offs to all of this, and that's the rub that the legislature has to address. You're going to have some measures that are really popular in the ag community, but being popular in the ag community doesn't mean that they won't face significant political hurdles, because your property tax is your funding mechanism for local services, and if you exempt or reduce the tax base for farm assets, that means local governments are going to have to either raise the tax on remaining property classes or reduce their services. So it is a big issue, Greg, that's out there. Maybe that's something that the legislature wants to take a look at. But the primary problem is that we're putting property tax on an asset that is used to produce the commodities that the farm raises. Other businesses are not so taxed in terms of their production type equipment in their process. And so that's the nuances there are quite unique, kind of beyond the scope of where we want to go this morning. But I do get into that in my piece, and just trying to raise some awareness of this, that, this is an issue that's out there, and maybe it needs some reconsideration.
Well, as an example for Kansas, talk about some of the changes that you suggest or might take a look at. How drastic would that have to be with the current tax laws that we have in Kansas right now?
Well, I think we can build upon the current structure that's there because we do have an existing structure for sales tax exemption on assets that are used in direct production. We always get questions with respect to that. The property tax issue is a little bit different. And, I can tell you there are dramatic differences, for instance, in the property taxation of a farm pickup truck here in Kansas compared to, for example, the state of Iowa, or a vehicle. If you compare just a personal passenger vehicle, if you compare Kansas with Iowa, it's not even close. Iowa is far better than Kansas on personal property tax issues. But again, as I say, Greg, if the legislature wants to look at relief on this, then they have to address the political fallout of this, because we rely heavily on property tax to fund certain services. And that means that they'll have to pick up that lost revenue somewhere else. So it's easy to say that we need relief. It's difficult, much more difficult to get it actually done in practice. But I think there's enough of a structure there in the existing rules in Kansas that you've got something to work from to try to provide relief. But it will take some effort by the legislature and a lot of thought to deal with this.
All right, Roger, we're out of time, but as always, you'd mentioned what we discussed today is on agmanager.info, but you've got other ways if people want to read more about what you're covering right now as well.
Yeah, I put those on my website, and some of these also go to my blog that's on RFD TV.
All right, sounds good. Roger, as always, we appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.